I'm Walter Isaacson of the Aspen Institute with Jeffrey Rosen of the National Constitution Center, and we're talking about how the Constitution deals with civil liberties and privacy in an age of technological change. Help us think that through, Jeffrey.
This is the most interesting question that the Supreme Court is confronting today: how to translate an 18th century Constitution into the 21st century. And the central text we're talking about is the Fourth Amendment, which says the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. In the 18th century, you had to break into someone's house with the writs of assistance and hated general warrants that sparked the American Revolution to read their diaries and riffle through their private effects. Nowadays, of course, we store all of our data on our cell phones or in the digital cloud, and no physical trespass is necessary to engage in a general search. So how should the Constitution respond?
So how did the Supreme Court, when they decided that police need a warrant to look at your cell phone, how did they find that in the Constitution?
That was an amazing decision. All 9 justices unanimously saying, although in the past we'd held that once you're arrested, the police can seize any item that's on your body and open it up, look at a cigarette package, for example, and check it to see if there's drugs, the court recognized our cell phones are not like cigarette packages. Our entire lives are there. You can see from our geolocational records and our digital data the political rallies we attend or the friends we associate with. Therefore, the court recognized wisely, you should need a warrant because the amount of information that's stored on our cell phone can reveal so much about us. We really need to protect privacy even if someone is arrested.
And so they based that on an 18th century phrase called unreasonable search and seizure?
They did, and even better, and this is the best part of the opinion, they invoked the general warrants and writs of assistance. Chief Justice John Roberts noted that James Otis had given a speech in 1763 denouncing the writs of assistance, which allowed King George to break into people's houses to see if they'd broken the hated tax laws. And John Adams said of Otis's speech, at that moment, the child independence was born.
So 1863, that's about 13 years before we actually declare independence. And that was one of the things mentioned, I think, in the Declaration of why we're declaring independence, right?
It was central on Thomas Jefferson's list of the hated imposts and taxes and taxation without representation. It was the paradigmatic case of an unreasonable search and seizure. And it's wonderful to see not only Chief Justice Roberts, but Justice Antonin Scalia, in a dissent from a case upholding the search of DNA, once again invoking the writs of assistance. You see judges today disagreeing about whether NSA surveillance is or is not like the general warrants that sparked the American Revolution. It's so exciting to see this history being debated and so relevant to our technological debates today.
You mentioned Scalia's dissent in the DNA case. One of the interesting things is this type of case doesn't break down on the typical liberal conservative lines. And somebody like Scalia, it seems, is quite forward-leaning when it comes to civil liberties, right?
That's absolutely right. These cases can often unite civil libertarian liberals and libertarian conservatives. But what's even more exciting about them is they can at times unite all 9 justices. It wasn't just the cell phone case. A few years ago, all 9 justices agreed that the police could not put a global positioning system device on the bottom of a suspect's car and track his movements 24/7 for a month without a warrant. They did so for different reasons. Some of the more conservative justices emphasized that there was an invasion of the guy's private property rights when his car was seized. Others, like Justice Alito, no liberal slouch, but he wrote a wonderful opinion, basically saying that we do have an expectation of privacy in the whole of our movements for a month, even without physical trespass. And the debate between Alito and Scalia about what the framers would have thought about GPS tracking was one of my favorite encounters in recent Supreme Court jurisprudence.
Well, that's, especially since Scalia is always an originalist and whatever, how did he find in the original text something that told him whether a GPS could be in the bottom of my car secretly?
Well, he had an analogy. He said that at the time of the framing, you could imagine a constable spirited under a carriage and eavesdropping on the conversation. So Alito shot back, well, since you'd need 1,000 constables to get that much information, you'd have to be a very small constable or a very large carriage.
And what about the DNA case? Explain the decision and Scalia's dissent.
That was an amazing decision. 6-3, Justice Stephen Breyer joined the more conservative justices in holding that when someone is arrested, their DNA may be seized and put in a DNA database, even if they haven't been convicted of a crime.
Why is that different from fingerprinting?
Well, that was Breyer's reasoning, in that we have no expectation of privacy in our fingerprints. It's just a form of identification, and therefore there's no privacy interest involved. Scalia strongly disagreed. He said DNA can reveal a huge amount of information about us. It's claimed that only the junk DNA or identifier is stored, but it could reveal our predisposition to illness or our medical history. And Scalia said our royal forebears, who were so appalled by the writs of assistance, would never have tolerated this royal intrusion into their mouths. He had a very vivid image.
Mouths meaning they would swab your saliva in order to get your DNA, and that was considered by Scalia an intrusion?
An unreasonable intrusion, and the majority of the court said it's really no big deal to have your cheek swabbed. We don't have expectations of privacy in our DNA.
Now, you talk about expectation of privacy, whether it's the fact that you shouldn't be able to be tracked or whatever, which we all were as kids in small towns. Everybody knew where we were. Where do you find that expectation of privacy in the words of the Constitution?
Great question. It doesn't appear in the Constitution, and it comes from a case from 1967 called the Katz case. And this is a gambler who is using something that many kids haven't seen today, a public telephone booth. And he's basically going into a glass telephone booth and making a call, closing the door behind him. He does his gambling. He's indicted. The Supreme Court says you cannot introduce the wiretap of his conversation because he had a subjective expectation of privacy that society was prepared to accept as reasonable when he closed the phone booth behind him.
Now, do I have an expectation of privacy when I put a piece of mail in the postal system?
You do. The Supreme Court has held, again, Justice Holmes, 1870, that when you lick the envelope and close it and put it in the postbox, the letter can't be opened without a warrant.
What about my email?
Well, that's a tough question. Congress passed a law regulating email privacy, but right now they're allowed to seize the header information, but not the content of email. And of course, we're having a big national debate now about whether the telephone numbers I dial, which is called telephone metadata, is or is not protected by the Fourth Amendment.
So is that sort of by analogy of what's on the outside of the envelope versus what's inside the envelope?
That is exactly the question that's going on. Judges are trying to figure out whether telephone calls are like address on the outside of a letter or not. But in some way, the analogy really isn't precise, because when you're talking about geolocational data, for example, that can reveal every move we've taken for a month, on the one hand, you could say it's like envelope information because I voluntarily surrender it to the phone company that records it. On the other hand, it can reveal so much more than even the letter that I write on the inside of the envelope that some judges are recognizing that you should need a warrant.
Well, all of this is quite amazing, particularly so that our Constitution, basically written at the end of the 18th century, is still a flexible enough document that we can use it to decide some of these cases, right?
It's a thrilling privilege that all of us have as American citizens to be able to make strong arguments about how to translate the Fourth Amendment into a digital age, and it's just exciting to be able to discuss it with you.
Thank you, Jeffrey.
Thank you.